C includes members not allowing conflicts of interest to override their professional judgment. The profession has wrestled with the issue of conflicts of interest and how best to handle them for a very long time. The Working Party is simply the last in a fine succession of bodies which have addressed this matter. And of course, the Morris Report in 2005 focused interest and attention on it and called on the profession to take appropriate action. The matter's also been addressed in successive reports by the Professional Oversight Board of the Financial Reporting Council, and that led to the establishment by the profession of the Working Party in July of 2010, following completion of the work on the Actuaries Code. We've been through, in those 2 years, as I mentioned earlier, an extensive process beginning with the issue of a discussion paper, subsequent targeted consultation, a consultation document which went out to all members, and that process of consultation closed at the end of last year. The consultation produced broad endorsement of all the proposals the Working Party had put forward in its consultation document, with the exception of the proposal that we should introduce a firm rule which, put briefly, would bar a scheme actuary from advising both the employer or funder of a pension scheme and pension trustees on issues to do affecting the funding and factors like benefit levels affecting the funding of a pension scheme. We've taken that feedback into account in developing the final package in ways which will be explained as we go along. We produced the final provisions and the feedback document explaining why we reached these conclusions on the 29th of June, and that's available to everybody on the profession's website. The package we've produced should be viewed as a whole. It's not a series of separate bits, but it has, we hope, coherence, and it hangs together. It builds on the conflict provisions in the Actuaries Code and combines targeted regulation in relation in particular to conflicts in pensions with guidance for all actuaries and a note for pension scheme trustees. And all that's going to be underpinned by a new CPD provision and professional skills training for actuaries. And I'm delighted that Tony Hewitt, who chairs the Professionalism Awareness Committee, is here this evening and will be participating in this seminar. Of course, conflicts of interest is a complex issue. There's not a one-size-fits-all solution. The considerations which affect conflicts can differ between one field of work and another, and also vary between actuaries in consulting roles, in consulting practice, and those who are employed by, for example, an insurance company. But there are, we believe, general principles or common principles which are applicable across all areas of actuarial practice. And the key to identifying those principles, indeed the cornerstone on which the package as a whole has been built, is the Actuaries Code. Now, the Code sets out the overarching principles which apply to all actuaries and not just in relation to conflicts. I should tell you that there is a light touch review of the Code underway at the moment. The Code came into effect in 2010, and 2 years on we agreed that we would review it, and that light touch review is likely to lead to a separate consultation process later this year. However, it's unlikely that the conflict provisions in the Code will change in substance. They are likely to be rephrased and reworded, and not least because we want to align our provisions with the requirements of the International Actuarial Association, for example. But the substance of what the provisions require is unlikely to change significantly. However, as I say, there will be separate consultation later this year about that. The Working Party reviewed whether additional regulatory provision over and above the Code is necessary. On the basis of the evidence we received, which I briefly referred to earlier, additional specific regulatory provision is not, in our view, required outside the pensions field. This is because the existing mix of regulation by the profession and external regulation by the FSA and Lloyds, for example, in conjunction with the Code, is, we think, an adequate and proportionate response to the conflict issue. However, the rest of the package, beyond APSP1 as revised, does cover non-pensions as well as pension practice areas. So the guide, in particular, is suitable, we hope, for all actuaries, whatever sector or field they're employed in. I pause at that point to see if you've got any sort of questions about the context that I've described. And if not, right, we will go on and I will ask Ben now to take you through the specific regulatory provisions in respect of pensions, and then Graham will pick up the wider aspects of the package. So it's Ben. Thanks.
Thank you, Philip. Good evening, everybody. A word then to follow on from the contextual picture that Philip has described on the specific pensions-related provisions. And these, as you'll be aware, have been addressed by way of amendment to Actuarial Professional Standard P1 and the introduction, in particular, of two new sections to Actuarial Professional Standard P1. I say a new Section 5 and new additions to Section 6, in addition to some new definitions. I'm going to talk to those in just a moment. In broad terms, the focus of those provisions, again as you'll be aware and by way of context, is on the role of the scheme actuary in relation to final salary defined benefit scheme actuary schemes. The provisions focus in particular on the potential for conflict between the interests of sponsoring employer on the one hand and trustees on the other in relation to those sorts of scheme. The provisions are intended to be balanced and proportionate insofar as they look at the circumstances, or are designed to target circumstances in which conflicts may arise in that context, the extent to which those conflicts may or may not be capable of being reconciled, managed appropriately, averted, and where they can be so reconciled, how that should properly be done. To be read in conjunction with, as Philip has already alluded to, the Actuaries Code. So not a piece of regulation in isolation, part of a package. The Code sits overarching everything, and particularly Principle 3 around impartiality in the Actuaries Code. Second word, technology. In a wonderfully sort of backwards piece of logic, I'm going to start at the end with the definitions, but just there's a logic to that. One of the specific calls that we have taken on board from the consultation was for greater clarity around some of the definitions we were using, and we've taken those, the Working Party's taken that on board, particularly around what we mean by advising, as in advising the sponsoring employer, advising the trustees. And we've come up with a term to which I highlight at this stage from the outset, a term client advice. We're talking about a client advice, and it's not simply any communication we're talking about. We're talking about advice in the context of a client relationship, a client engagement, which you as scheme actuary have with the employer on the one hand and all the trustees on the other. And in particular, when we're talking about advice, we're talking about something which involves a material element of judgment or analysis. That was the phrase that we came up with. Okay, so we hope that offers some elucidation around that particular concept, which is critical actually to the provisions as I now turn to them. Section 5 then, 5.1, 5.1 is initially a contextual piece, directed specifically at scheme actuaries, as is the whole of Section 5. A reminder that you should have regard to Principle 3 of the Code, including, and here's the principle, to disqualify yourself in the event, the important principle that you should disqualify yourself in the event that in the event of an irreconcilable conflict of interest. So if you have a conflict, you can't reconcile it, you ought to be disqualifying yourself. The Code says that. This sets out that principle as a reminder from the outset. Paragraph 2, in short form, 5.2, proposes another important principle. It's about disclosure. So to the extent that you're acting as scheme actuary, your obligations to the trustees, and either you or others on behalf of your firm of whom you are aware are providing client advice, are working for, in different capacities, for the employer. According to this provision, you need to disclose that fact. You need to be open about that. You need to bring that to the fore. This is not dissimilar to the version that was in, slightly reordered, but similar requirement was in the pre-consultation paper. It's slightly broader to the extent that it includes anybody of whom you, as scheme actuary, are aware who is acting on behalf of your firm, in effect. But you clearly, it's subject to you being reasonably aware of them. So, first principle coming from the Code, disqualify yourself if you can't reconcile your conflict. That is very clear. Second principle, disclosure, where there is work being done for both trustees and employer. This is I suppose, one of the most significant new provisions, which is a direct response to the consultation. Again, relating to the scheme actuary and relating to the individual role and individual position of the scheme actuary. We've moved away from, as Philip has alluded to, a blanket ban on scheme actuaries, a very specific rule banning the provision by scheme actuaries of certain sorts of advice to the employer. What we've produced instead is what we consider to be a more principle-based, more flexible, but nonetheless robust presumption. In legal terms, a rebuttable presumption. And the rebuttable presumption is to the effect that you will have an irreconcilable interest if, as scheme actuary, you provide advice to the sponsoring employer in relation to funding or benefits in relation to the scheme. That's the presumption, and that's the presumption that you're required to take on board as scheme actuary. However, it's not absolutely blanket. We've accepted and taken on board all of the important input which has been provided in consultation, that there may be exceptions where actually conflicts don't arise in important circumstances, and actually where scheme actuaries have some sort of obligation to provide advice to the employer. However, what we've sought to do is to capture that as, in effect, an exceptional circumstance, and required the consideration of certain criteria before you depart, which you have to consider before you depart from the presumption. And those criteria are set out at paragraph 5.4 of the provision. And in short, they require you to have regard to the public interest, including the public interest in safeguarding the interests of scheme members. And you'll see this from the draft itself, so the standard itself. The extent of the trustees' independence and expertise, any relevant legislation. Clearly, if there's a legislative requirement for you to do something, you need to heed it. What the scheme rules say, and the extent to which, if the scheme rules are incompatible with what professionally you ought to be doing, the scheme rules can or cannot be altered. And finally, whether it is appropriate to resign from one or more appointment rather than depart from the presumption. So there's a very clear set of criteria. They're principles-based, they require judgment, but by way of an important guide as to the factors the working party thinks you ought to take into account if you're contemplating departing from that presumption. against acting and advising in those circumstances. This then is supported by a recording requirement, paragraph 5.5, to the effect that you must record any decision to depart from the presumption, and the reasons for that decision, including the reasons for concluding that in the particular circumstances there is no irreconcilable conflict. Now, that was a very carefully considered provision. The point of that, the outcome we're trying to achieve there, is actually one of, in short, focusing minds around the importance of the principle which underpins the presumption, and ensuring that where you are contemplating departing from it in exceptional situations, you're really applying your mind to the reasons for that and the reason that's appropriate. And actually, and this I think supports actuaries out there in actually recording and being able to demonstrate why you've done that. Actually able to produce something that sets out some sort of rationale, which has some sort of reasoned basis to it as to why you've considered that appropriate. And to bolster the provision, there can be concerns that rebuttable presumptions are not as strong, not as robust in the public interest as a blanket ban. We think it is appropriately flexible, appropriately principles-based, but nonetheless, what the working body has said is, if you do depart from it, it should properly be on the scheme actuary to justify why they have done so. So there is an onus in legal terms to do that if you were reasonably asked to explain why you'd reached the decision you had done. I'll keep going, if I may, to the end of section 5. I might pause there before I change tack into section 6 in case there are any questions as we go along, or points you wish to raise. 5.6 still has its focus in the scheme actuary, but applies more broadly, has a wider, firm connotation in the sense that, and application, in the sense that it imposes an obligation to have a plan, have a written plan, so that where you have a conflict which you consider can be reconciled, and you've got, in circumstances where you've got a plan, a conflict which you consider can be reconciled, you will nonetheless have a written plan, transparently setting out the way that's going to be reconciled and managed. And the way in which that operates is that the over and above the code, APSP 1 requires you to consider whether there are others who are providing advice in relation to the scheme to the employer, and if there are, to produce a written plan having regard to certain considerations and requirements in the standard, all included in that plan, and taking account of everybody involved. Now, the detail of that is set out in 5.6. 5.6.2 states that the plan should take account of everybody who, to the scheme actuary's knowledge, is involved in the provisional review on behalf of the scheme actuary's firm of client advice in relation to the scheme to either the trustees or employer. So it's comprehensive in that sense, it has a firm, wide application. There are points which have a number of points there which were already in the pre-consultation draft and actually emerge from proposals, some of which emanate from Morris and go back as far as that. So 5.6.3 states that so far as necessary to safeguard the interests of the trustees, the plan provides for the waiver of any duty of confidentiality which would otherwise be owed to the employer. Again, focusing on the transparent safeguarding of the interests of the trustees. 5.6.4, again, a provision that was already there. The terms of the plan are such that if it becomes inappropriate for the scheme actuary to continue to provide client advice to both the trustees and employer, and the idea is you should be reviewing this as you go along, it will be the trustees who have the option to continue their appointment. Again, focus on safeguarding the interests of the trustees. 5.6.5 is a new provision designed to bolster these provisions and again responding to feedback received. To the extent that to the effect that the scheme actuary must be reasonably satisfied that the trustees in agreeing to the plan are appropriately informed as to its implications. The public interest concern there, which if it's not obvious, is that you need to have the trustees' consent to this plan, and it needs to be consent of some level of quality. And as a professional, as a scheme actuary, just as this would very obviously be a requirement of a lawyer and other professionals, some sort of obligation, responsibility to satisfy yourself that this is properly informed consent, to use legal terminology. One way in which we envisage you might satisfy this requirement is to suggest in appropriate circumstances that the trustees consider taking their own independent legal advice, if that's appropriate. You clearly can't dictate to the trustees, it's possible for you to know absolutely what is going through their minds, but you have some level of professional responsibility to be satisfied in particular that they are appropriately informed. That then is section 5 and the provisions around particularly focusing on the scheme actuary and how they've evolved post-consultation. I'm happy to pause there if you have comments, questions at that stage, or to come on to section 6, which I will do otherwise next. Yes, please.
Pete Sayers, Affinity Consulting.
Hello.
I just want to concentrate initially on the slight differences between 5.6 and 5.2 and the definition of client advice that you haven't brought out in your presentation so far. It's quite clear from the definition of client advice, it's advice given by a member of this profession. So I work for a consultancy, pension consultancy, where we have consultants who aren't actuaries. Mm-hmm. And whilst advice by someone who isn't an actuary to an employer would be caught by 5.2, because that just refers to work yes. Undertaken on behalf of the scheme actuary's firm. Mm-hmm. The detailed requirement on 5.6 to actually have a conflict management plan only applies where the work constitutes client advice. And as I've mentioned, the definition of client advice is specific in that it's advice given by a member of this profession. I'd also like to, if I may on the same topic, cross-refer to the guide for trustees, where this particular aspect hasn't been picked up. And the guide for trustees specifically says the scheme actuary must ensure that a written conflicts management plan is agreed with the trustees and the employer if the scheme actuary or anyone else in the scheme actuary's firm is advising the employer in relation to the scheme. And that statement in the guide to trustees is inconsistent with APS P1.
Thank you very much. I'll give you, we're going to take away some of the comments you make that are helpful input. I'll give you an immediate thought and response, and maybe that Graham or Fiona or Philip have something to add. 5.6. Well, firstly, I think it's appropriate that we're focusing on the advice given by members. And I should say that from the outset. To the extent that there's possible lack of clarity in the drafting, we need to address that, and I think that's helpful. It's appropriate that we're looking at advice by members. It's them, frankly, that we regulate, and we need to be proportionate. However, 5.6.2 does state the plan takes account of everybody who, to the scheme actuary's knowledge, is involved in the provision of review on behalf. So it is involved in... Of client advice. Yeah. Where it's involved with the advice coming from a member. It's just that I'm thinking that if trustees looking purely at the guides for trustees, they may think that there's a specific requirement to have a conflict management plan in place where the advice coming from the employer, going to the employer, is from someone who isn't an actuary within the same firm. Now, I'm not saying that there shouldn't be a conflict management plan across the whole board, but I'm just saying that there is this inconsistency between the two. Can I go? I'll try and suppose we're intending here, to the extent that as I say, that there are questions of are enhancing the clarity of what we've drafted, then that's obviously something we take on board. What we're intending here is that the responsibility is on the scheme actuary to produce the plan. It's a specific obligation on them, they're the person in the focus of this provision. And that plan should take account of everybody, including members specifically, but everybody involved in the provision or review. So that contemplates the process, if you like, by which that client advice is produced. And I think we would say, and Graham in particular may wish to chip in here, that incorporates within the scope of the plan more than just significant others, in short, who are involved in the production of that client advice. We will certainly look at the guide wording to which you prefer.
If I may just raise a sort of separate thing which may be picked up later, the definition of the term firm,
Yes.
where you're part of a larger group. And I don't know whether that's something that Fiona is going to pick up on, the practicalities. Again, with my own firm, we're part of a larger group that has sort of shared registrar services, for example. And it's a case of, to what extent do you have to look beyond sort of the actuarial practice? Again, if you're looking at the definition of a firm, it is quite explicit that it does refer to connected entities under common control, ownership or management.
Yeah, it's deliberately so, and I take the point. It is, however, restrictive. So if you're looking at 5.6.2, takes account of everybody who, to the scheme actuary's knowledge. So we can't impose a requirement such that you can't reasonably be aware of somebody in a sort of related entity somewhere else in the world or something of that nature.
I think when we had discussions on the Actuaries Code, one of the issues was that, post-event you may be accused, well, you should have known, something. It's a question of how much do you actually dig into this?
As a lawyer, I would say you have to take, this is a famous expression of reasonable steps, whether it's quite that. It's certainly something that passes the test looking backwards, that you've acted reasonably, you've perhaps made reasonable inquiry. You've certainly not turned a blind eye, but you can't be expected to have gone to the ends of the earth. You can debate that. We've deliberately been conceptual and principled in our approach, and there's a judgment call to be made there. Perhaps one to continue afterwards. Yeah, thank you. I don't know if Graham wishes to comment on it.
I'll only comment on this instead of the original question, which is identifying that there is quite a difference between 5.2 and 5.6. 5.2 is potentially much wider in scope because it just means that there's anybody in your overall firm on a very wide basis doing anything for the employer, including presumably cleaning the toilets or something, that sort of work, then that disclosure requirement under 5.2 arises. And that's the principle of it, casting aside exactly how the definitions might or might not work. Whereas 5.6 is looking much more specifically where the work that's being done is in relation to the particular scheme that the person's a scheme actuary on, so that immediately narrows it. And there is a further narrowing in relation to the client advice, which might or might not in all circumstances be absolutely intentional. But the principle is that there's obviously a different level involved where you're actually talking about work for the employer in relation to the scheme. And whilst it might be possible that you can actually avoid this requirement if it's not delivered by a member, that wouldn't be the spirit of it, I think, is what I would say. And the bottom line point, if I may say, is that one that Ben made very ably, which is that both the provisions are inevitably cast in a way which reflects the fact that the institute and faculty's jurisdiction is over its own members. It doesn't extend beyond that. So they pin responsibilities on the scheme actuary, and both of them do that in the way that they're worded. It's just that the scope and nature of those responsibilities is different from, as Graham described, from 5.2 to 5.6. Any others on section 5? There's one over there.
Gordon Sharp, KPMG. 2 points, if I may, which probably are takeaway points and may even be perhaps material for further case studies for your further CPD. On the scheme rules point, 5.4.4, I think to the layman that's almost written as if it's in the actuary's power to change the rules, and of course it's not. It's the trustees, and usually needs employer consent as well to change scheme rules. So in this commercial world, I just wondered to what extent it's reasonable if the client turns around and says, yes, Mr. Actuary, I'll change my rules because you're asking me to do so. And how far would it be reasonable for the scheme actuary to pick up the tab for all the expensive legal advice that would go with that? And I say that only half jokingly. The other point, and this is something that we're certainly finding more common since we had the consultation last year, and that's the growing establishment of joint committees between trustees and employers, whether it's under the heading of a de-risking committee or whatever. That gives any one actuary, whether it's a scheme actuary or another advising actuary, I think two problems. One is the commercial problem of actually commercially who is the client, because such bodies will normally be committees rather than formal entities, so he has to have a different engagement. But part of that engagement will be to give advice to that joint committee, where very clearly it is made up of trustees and employer. So quite how that works around all the provisions in here, I think is something that merits further thought and further discussion with everyone.
Very much. We'll take a quick two quick responses, I think.
If I may, the first one, hard to change the scheme rules, where indeed acknowledge that may be the case, and that was one of the considerations, factors that led the working party, I think, to its sort of final positioning on this. At the same time, I think it's important to note this is one of a number of factors that we say is important to consider. And ultimately, what this is saying to my actuarial mind, my legal mind, is you need to be mindful of your public interest and professional obligations. We place those in the context of practical reality, and we recognise the practical constraints on you. But the practical constraints do not necessarily have the final say. They don't necessarily drive the final answer if there's a fundamental professional problem. And therefore we position it as a principle that this is something you need to consider. And whether in fact they can be changed if it's the scheme rules that are causing a problem. It may not be. Joint committee point is a very, very interesting example, thank you. And it just occurred to me that, as you were saying that, it perhaps emphasises and focuses the importance of identifying and being clear as to who your client is. And that's something which is addressed as a chapter in the guidance, actually, and something we very much focused on, and something that we'd be happy to discuss further at the appropriate point. Clearly an important point. If there are no other questions for the time being, I will move on. Conscious just a little of time. I'm going to move on to section 6, if I may. Section 6 seeks to extend the principles I've just described in section 5, which apply to scheme actuaries, to other actuaries involved in the pensions context. And section 6, paragraph 6.4 to 6.7 continue to apply to defined benefit final salary schemes, but to others other than the scheme actuary, other actuaries involved. 6.4 is a catch-all provision to the extent that it applies the requirements in relation to disclosure and the requirement to produce a plan to others who are directly responsible for the provision or review of client advice to the trustees of a relevant scheme, but who are not acting on behalf of the scheme actuaries firm. In other words, those in that sort of position of responsibility who would not have been caught by the obligations on the scheme actuary and fine, catching those. Extending the same principles, however. Paragraph 6.5 to 6.7 extend provision equivalent or very similar to those in relation to scheme actuary in relation to the rebuttable presumption principle. And it applies that presumption to any member to the extent that he or she is involved in the provision or review of client advice to both the trustees and employer of a relevant scheme, where that client advice in each case relates either to the funding of the scheme or to any matter which is a direct bearing of the benefits payable under the scheme, same as for scheme actuaries. And that client advice in each case requires a material element of judgment by that member. So we are introducing a threshold in terms of those to whom it will apply. Again, attempting to be proportionate in the approach. The logic there is quite clearly, there are principles here that apply to scheme actuaries. There's no reason in principle why they shouldn't also apply to other actuaries exercising significant roles in the provision of advice, but perhaps not absolutely to everybody involved. And there are similar recording requirements, and indeed it almost is on the member just as it is on the scheme actuary to justify where they have not applied that presumption or they departed from that presumption, and they're to have regard to the same criteria, the same factors as a scheme actuary would have done under section 5. And that takes me, I think, to paragraph 6.8 of section 6, which, again, consistent in principle with the substance of the pre-consultation draft, extends those principles that I've just described around, in short, disclosure, plan, and the irreconcilable conflict presumption to others, pensions actuaries who are acting in relation to other sorts of scheme. But we've recognised that we can only do that at a principled level, and what we're calling for and what this standard requires is for the exercise of judgment from others in those acting in all sorts of different circumstances, whether in relation to public sector schemes or other types of scheme which are not scheme actuary schemes, to look at these principles and apply them, and to record the steps you've taken in applying those principles at 6.8.3. So, very deliberately calling for judgment, again, applying principles, allowing flexibility with guidance to support the standard. I hope that that's of some assistance. If there are questions at that stage, I will otherwise pass to Graham to take you forward in terms of the other elements of the package. Thank you very much.
A point that I would stress before I start the other bit on 6.5 is there's some quite critical points about exactly who is defined as being in this group of people who are subject to 6.5 to 5.3 in terms of the judgment they're exercising. And there is a difference there there's a relation to the members concerned exercising judgment, which is actually slightly different from the definition of client advice, which has both judgment and analysis. And so if it's not obvious to you from the comments that are included in the consultation response where we try to deal with this, what this distinction is, then you might want to ask about it. So I'm saying, but if you're happy with it, then I'll carry on. But there is a difference there, and I didn't want that to be lost. Is anybody happy with that?
You tantalised people there with this. We'll come back to it at the moment. People are mulling it over at the moment in their minds. Let's come back to it if it's an issue at the end, which would. Okay.
Right, as has been stressed on various occasions, Although the APSP one will be the thing that people naturally focus on most, and that's probably quite right, as it's the mandatory provision, this is a package. APSP one is just one of a number of elements of an overall package designed to help take the conflicts of interest issue forward within the profession and provide a sort of toolkit that enables us to handle this issue as a profession for the future. And I'm just going to touch on three other aspects of the package. The first one is not actually really on paper at the moment, because this is the ongoing commitment which Tony and his committee are grateful they'll be taking on to make sure that there is adequate CPD provision to help actuaries get to grips with conflicts of interest in practice. So, that's something that respondents stressed that they really wanted, and the profession will be looking to deliver. I can't stand here and say it will be delivered, because I won't be doing it myself. And it's something that we actually have to rely on other people to do, and often that will actually be volunteers needing to come forward and run CPD events. But anyway, that is the objective of the profession, is to have more of these CPD events. You could say they'll be starting with these events in the autumn, when we'll, which Philip mentioned at the beginning, when we'll be looking to get around and about the country and talk to people from different practice areas about the outworking of the new package. And tonight, as you may have noticed, we're aiming mostly at sort of professionalism committee chairmen and other people with specific responsibilities in their firms. But as time goes on and it starts getting implemented within firms, we think there'll be more general questions that it'll be useful to discuss with members of the profession. So that, if you like, is the first phase of the education CPD thing that this working party will essentially be doing. But from then on, it's more down to the normal CPD committees. And amongst other things, one of the things that I believe there's a commitment to do is in the new professional skills courses that will be coming online next year, there will be specific stuff in relation to conflicts of interest with case studies seeking to help actuaries get to grips with real life issues for their own practice areas. Second, we've got the guide for actuaries, which, although there were various points of detail about what might or might not go in it, this was generally welcomed in the consultation responses as a useful tool. And it's important to stress that this does differ from a regulatory point of view from APSP1. APSP1 is a mandatory standard. The guide for actuaries is non-mandatory resource material. And whilst it is almost certainly true to say that it will be taken into account as best practice if anybody asks what you've been doing, it is not mandatory, it is not a rule book, it is not necessarily something that you have to follow to the letter and tick every box. What's really is good to come out of it is if people are reading it and it's stimulating thought. So that even if they actually say to themselves, well, I don't think this is really quite the way to do it in my circumstances, that might well be the right conclusion, but at least it's been thought about, and that's one of the key aims really of it, is not to set out a whole load of rules as to how things should be done, but actually to help stimulate thought so that actuaries can address the issues that arise from day to day. There's a list on the slide out there of some of the revisions that have been made to the consultation draft. I wouldn't claim that the distinction between identifying and managing conflicts would have been addressed in agreement with what everybody else would think is the difference between the two, so don't necessarily get too hung up about that, about what's down as identifying and managing. But there has been a bit more of an emphasis on that earlier stage of identifying the conflicts rather than managing them once they've actually been identified. And among the other things, there are more case studies over a wider range of practice areas, and more information in relation to separation of teams within firms and Y models. There's more detail on that. And finally, amongst the extra resource material, we've got the note for pension scheme trustees. Its name has changed, as you probably have noted, from guidance for trustees to try and make it clear that we're not seeking here to tell trustees how to go about managing their own conflicts. It's not really guidance for them, but it's a resource that actuaries can use if they feel it's appropriate, if it actually would help them to explain to trustees the professional requirements that they are under. And as a secondary issue, that might actually help trustees to deal with their own conflicts or to understand things better, but that's not the main purpose of it. The TPR has been consulted and they're happy with it. And one final point that actually is not on the slide that I think is worth drawing out is that there have been some changes compared with the draft, and a particular change was to expand the example section so that there were more instances, or perhaps with some instances, I'm not sure there were any in the first case, some instances where the conclusion was that the actuary could carry on advising two parties in a situation that might give rise to a conflict. But in each of those occasions, I think one was to do with accounting and the other one's to do with advising two schemes of the same employer. Examples are given of scenarios in which it may be appropriate to carry on, and examples of which things might change and then it may not be. And the object of that is not actually to set out a specific template as to what's in and what's out, but actually to help illustrate that each case has to be considered on its merits, and there will be times when it's okay and times when it's not okay, and judgments will have to be made about when those are, depending on the particular circumstances. And stuff on the bottom now, I don't know if that's the only bit of feedback we've got, but it's at least nice to know that the first comment we have got there is that pension trustees found it helpful. The first one. We'll see. Any questions on those before we move on to Jim? Yeah, on over there.
Gordon Sharp again. Graham, I fully support what you've just said about what the examples are intended to be, and that they're sometimes appropriate, sometimes not. But I and certainly my colleagues found example 6 written in a particularly black and white way, and implying almost that it was the actuary who was responsible for negotiating money with the employer on behalf of the trustees, when it's not. The actuary simply putting forward funding advice. The affordability issue, which is what the issue here really about, is not an actuarial conflict, it's a different conflict. So we just found that the black and white nature of this being put in front of trustees without all the proper words you're able to say when you're describing it as perhaps not helpful.
Okay. They're not meant to be black and white, but maybe they're across as that.
Another question, just along the road.
As Gordon Sharp has raised a second question, I thought I'd do one as well. Pete says, with the guide to actuaries, there seemed to be more or less like a throwaway line on page 13, which referred to a conflict handling plan in most circumstances where exceptionally the same firm is advising both the trustees and the employer. So it seems to be saying that where you're expecting if a scheme actuary is coming from one firm, the firm should not be advising the employer. And so it seems to be very much alike.
That's fine, that's well spotted. That's an error that was spotted this afternoon, actually. That the word exceptionally are correct in there because the subsequent words had been slightly different before. They were talking about individuals, so that exceptionally is wrong.
Thank you.
I think that's fair. We'd agree there.
Yes.
Yeah. Thank you.
Could I just say on all these comments that we're giving about the guide, I mean, given the complexity of the issues and the amount of effort that's gone into creating this material, it would be very surprising if it was perfect on day one. And we are gathering points like those that Gordon and Pete have made, and we will no doubt be producing a version 2. And of course, we're able to update the web version much more frequently and easily than the printed version. So we thank you for these points because they're well made. And there's another one here.
Mark Howard from Barnet Waddingham. I found the examples helpful, although perhaps a little bit contrived. I could probably think of another half dozen examples which would be much more tricky. I'm not suggesting you amend that note for trustees, but I wonder whether, looking forward to the presentations you do in the autumn, whether in the meantime, for example, the case of joint committees that was mentioned earlier, things like that, if we can feed those into you, you could actually give more tricky examples to members of the profession, because otherwise they will be coming along on the day, I suspect, with those. And if we can give you advance notice, I think that might help.
That would be very helpful.
Yeah.
Go on.
No, yes, I was going to say, yes, that would be good. Either for those or for the professional skills courses as well.
Yes.
Good case studies would obviously be useful.
Exactly. Thank you. Thanks for the offer. Okay, we're ready to move on. I think Fiona is going to take us through the practical impact on firms and some thoughts about what firms might like to be thinking around and addressing as we move into the implementation phase.
Like many of you, I'm actually chairman of a professional committee, so that some of the issues we're all going to be having to look at. What I've done is there are some slides here which are really prompts for the rest of the discussion. Obviously, you've already covered some things. They're not exhaustive, and so Pete, the definition of firm does not appear, but thanks for raising it. Let me get my retaliation in first. There's a little bit again on pensions, which everyone will understand, and then some general things across the piece, and also coming back to what more you can expect from the profession in this area. So on the pensions side, there are sort of two elements here. One is that, as you know, APSP1 comes into force in July 2013, but it is strongly encouraged to adopt early. The second thing is, there is a list up here. I'm not going to run through everything, but obviously there are, at a firm-wide level, we're all going to have to decide how we're going to help our scheme actuaries tackle some of these issues. And, you know, for example, we haven't concluded our debate, but